Hi, everyone, and welcome to the first episode of Associate Chatter with Mike McDonough, AJ Wen, and myself, Gopal Ganamraj. We're all associates at SpencePC, a law firm in Chicago, where we do IP and complex litigation. The main goal for this podcast is to have a free-flowing conversation between three associates from different personal and technical backgrounds regarding current legal topics, so that we can keep you, the listeners, up to date with the happenings of the legal world. So how about we get into it? We'll do some introductions to start here. Like I said, my name is Gopal Ganamraj, and I'm from Cincinnati, Ohio. I have a background in electrical engineering, focusing on a variety of technology, from power systems and control systems at a macro level to home appliances that utilize wireless technology. I graduated law school in 2017, and before I came to do litigation work at Spence PC in October 2019, I was doing patent prosecution work for one of the largest and oldest IP firms in Cleveland, Ohio. So that's a little bit about me. How about you, Mike? Tell us a little bit about yourself.
Sure. I'm an associate attorney, obviously, at Spence PC, where I focus my practice primarily on traditional commercial litigation matters, from contract disputes to trade secrets and any range of business torts. And unlike Gopal and AJ, my background is in the super highly technical field of political science. So I tend to bring a different approach to a lot of these issues than Gopal and AJ do. I've gotten since I joined Spence PC probably about a year ago. I've gotten the opportunity to delve more into the IP side of litigation, which I've really enjoyed. I really enjoy working with a lot of the other associates who have the more technical background, and I think that my stance or my focus can shed a new light on that and can really bring a different perspective. And so I think it's been great. Basically, I try to spend as much time in court as I can, but based on the pandemic and everything that's going on right now, the courts are closed, and I'm here with you. So AJ, take it away.
Well, my name is AJ Wen. I graduated from the University of Illinois, Chicago with a degree in biochemistry, and then attended the University of Kentucky, go Cats, for law school, where I competed on the moot court team. I have experience prosecuting and litigating patents in the electrical, chemical, and mechanical arts. I started at Spence PC in August, but before that I worked at a firm outside of Columbus, Ohio, and I was the intellectual property section chair for the Ohio State Bar Association. So today we're going to be discussing artificial intelligence as an inventor. Now, the main clause that we're dealing with here today comes from section 35 USC 101. That states, whoever invents or discovers any new or useful processes, machine, manufacture, or composition may obtain a patent thereof. So the issue becomes whether artificial intelligence that is able to create an invention from little input of the person operating the device can qualify as an inventor. And there's actually a certain group called the Artificial Inventor Project that has been pushing or lobbying for this to be the case.
As AJ introduced, the Artificial Inventor Project has raised some very, very necessary questions that are needed regarding inventorship and in relation to artificial intelligence. The AIP, as stated on their website, is dedicated to seeking intellectual property rights for artificial intelligence. Off the bat, let's make one thing clear about the AIP. They're not advocating necessarily for artificial intelligence to own the patents, but instead for artificial intelligence owners to own the patents, while the artificial intelligence itself is listed as the inventor. And I think we all can see that this raises plenty of questions, even as far as litigation goes. Mike, do you have anything that would come up as far as litigation goes, or anything that sticks out to you?
Yeah, I started looking at the AI, and basically whenever you have machine learning that's now churning out information or it's churning out programs that are then attempted to be patented, it's going to raise a bevy of different types of litigation issues. And I think it's kind of ironic, I guess, to say the least, that you have machine learning that's attempting to make life easier, or it's attempting to create something aside from humans but it then raises a slew of other issues. And frankly, I think that's more human in inception than anything else. But I think there are two main litigation issues that we're going to have. One is we're going to have way more infighting regarding inventorship pursuant to 101. And then the second, I think that we're going to have potential infringement liability. Both of those issues are going to be litigated extensively going forward. And frankly, that will always happen. These types of issues come up, and they will always happen whenever you have developing areas of technology where the laws and the case law really hasn't caught up. Like I said, the first issue that I think we're going to have is we're going to have much more infighting regarding inventorship. I know we're going to talk about this in a minute, but the Davis ruling for the USPTO, we now know that artificial intelligence can't be named as an inventor. So the question is, well, what do you do now? Well, you have to identify the human inventors. And, that may seem like a very simple concept, but the execution is very difficult and it requires a legal analysis. So
and on top of that, Mike, I think just as having the inventor or the artificial intelligence themselves be named the inventor, I think that itself also raises questions, because I think we've talked about before where what does it take to be an inventor? What kind of mental state do you need to do in order to get to that point of being an inventor? Because if it's the artificial intelligence itself that is creating the technology, then why would the inventor themselves be named as, or the owner of the artificial intelligence be named as the inventor?
There's a couple different public policy issues that also have to be discussed with respect to artificial intelligence and the USPTO. So two of the main reasons why the USPTO exists, the first one is to act as a place for the systematic disclosure of ideas from inventors and companies so that the public has access to new technology, and people can therefore build on all these ideas, and it makes innovation more efficient. The second is to allow companies and inventors an opportunity to recoup all the investment that they've undertaken to come up with this idea. Now, if you have a robot or a computer that can simply generate patents or ideas almost simultaneously, do you think that that's in line with the public policy for the current the current state of the USPTO?
I think, as we'll get into with Davis was able to recognize a problem and find a solution. It wasn't necessarily programmed to solve a specific solution. This type of artificial intelligence was able to analyze the types of problems there are, and analyze that problem and come up with a solution for it. So by coming up with that type of solution, I think there is inventorship as far as artificial intelligence goes.
Begs the question then, at least from the legal standpoint, because we know that, what we touched on earlier, that, inventorship is based on conception. But I think we need to get away from the idea in our head that patents are based on one man or one woman in their garage coming up with an idea, putting it into practice, and then filing for a patent. These AI systems or these programs or whatever you want to call them, these are created with teams of people, right? And we're not talking about one or two people. We're talking tens, if not hundreds. And I think that's one of the issues. And when you get into the issue of, okay, if the AI itself can't be an inventor, how far back do we move the stick, or who all do we look at as potential inventors? And this is coming back to what I said earlier, you're going to get a lot of infighting where everybody may have been on the same page regarding conception, creation, or implementation of these AI systems. When it comes to money and when it comes to the ability to patent the product, then people are going to start getting in line and start making sure that they get their own.
I think my biggest question, I guess, that it comes back to is something you mentioned earlier, which is conception. So the MPEP defines conception as so they say that the inventor must form a definite and permanent idea of the complete and operable invention to establish conception. My question to you would be, are these individuals that are creating the artificial intelligence, who are just creating artificial intelligence generally, not to solve a problem, specific problem or anything, but generally, are they able to establish that sort of conception?
Honestly, that's a fact-specific question, but
Mhm.
my general answer to that would be absolutely. And frankly, it's like I said, it's how many steps back do we take now? If we create a program to identify and then solve other issues, who then and then it then creates a program, how many steps back do we take? And I think one of the biggest problems with the AI is that the the legal world has not advanced as quickly as the scientific world has, and that's
You can say
always
that
been
again.
it's 100, it's always been an issue. So what do you do now is you try to, at least from a litigation standpoint, you try to shoehorn your facts into the pre-existing framework. So that's this whole issue is, we're trying to shoehorn facts regarding AI into the already existing framework of inventorship, and that's going to be litigated for some years, or at least until we get some direction from Congress or whatever legislative body that might have an input here. But I think it's kind of funny that you know you try to use these incredibly scientific and these incredibly technologically advanced concepts and reduce them to something as generic as inventorship.
It also devolves to a philosophical conversation that I don't think any of us are qualified to answer. Is
I'm
like
sorry,
when
Jay, did you not hear me? I have a degree in political science and
oh
an associate's degree in philosophy. I didn't take all the philosophy classes because they were easy.
all right, Mike. Well, then, at what point do you think that a computer becomes a human being?
I'm going to have to check my notes and get back to you on that one.
Okay, all right. Difficult question though, because all of inventorship is tied back to machines at some point. So most patents are incremental inventions on pre-existing technology, and a lot of inventions use technology to generate new inventions. And so, at what point is this machine, although it can come up with new ways to solve a problem, at what point is this? Is it truly conceiving of an idea, or is it just, doing what we've always done, inventing on top of previously existing technology? So that's a question that I don't think any of us are are qualified to answer.
It's a way for us to talk about. Mike even mentioned it. Just the decision the USPTO made about DABUS on April 22nd, 2020, in relation to a application that was submitted with DABUS, which is an artificial intelligence listed as the inventor. And the USPTO pretty much decided that artificial intelligence could not be listed as an inventor. And they list out all these statutes and all these cases. Does it seem like the USPTO just sidestepped the question that is forward-looking as to how to deal with machine learning and artificial intelligence by firmly rooting its decision on statutes and cases? Because none of these statutes and cases necessarily dealt with artificial intelligence. So what does the USPTO have to do, I guess, moving forward?
Well, I think that in a way they did kind of kick the can down the road. I think that they're correct in in their reasoning, in that the statute is pretty clear that it states, whoever invents a new idea, it isn't whatever. And then if you look at a lot of other language contained within the MPEP, it's very focused on a person.
Yeah, a natural person, yes.
A natural person. So given that pre-existing language, I can understand where they're coming from, but this is an issue that will need to be dealt with, and it'll need to be dealt with quickly, especially as machine learning continues to grow and other types of quantum computing arise.
reading the Dabas opinion, and did they sidestep the issue? Absolutely. Are they required to? Kind of in this situation. USPTO is like any other either judicial body or court or circuit court or federal court that you want to talk about in terms of their obligation is to interpret the laws and interpret them in terms of the facts that are presented to them. Did I expect the USPTO to come back and say, you know what, Dabas, you are AI, you are an inventor? No, absolutely not. And frankly, there's a lot of talk, even outside of technology and the law about, activist judges or anything like that. It's not the judge's position to dictate the law or to establish the law. It's the judge's job to interpret the law and set precedent. Frankly, the USPTO, I think, they did a good job of interpreting things like 101. I think one of their first paragraphs in the Dabas ruling was just to point out the intro to 101 that basically says whoever, and they bolded it and they italicized it and they made sure everyone knew it. And I think it's difficult to say that the USPTO was wrong when they have nothing but the plain meaning of the law, and then they have nothing but case after case after case, and we all know this, we've all read this, of basically the humanization of inventorship. It's not whatever, it's not it's he, it's she, it's whomever, it's who, it's and while these may seem technical or these may seem like dicta, they're not. And frankly, when the USPTO says, okay, I have all of this information before me, and this can guide my decision, that's what we're going to go with.
I will say, Mike, though, that this goes back to, I think, what you were saying earlier, where technology is ahead of where courts are nowadays.
And frankly, to the second point, I think there's going to be at least a small uptick in potential infringement liability. And it comes from the idea that, what if your artificial intelligence creates something that infringes upon someone else's IP? There's certainly no question that infringement is a highly litigated issue now to begin with. So now if we're taking a step back in using artificial intelligence, or frankly taking a step forward to use artificial intelligence, the same types of illegality or litigation issues will potentially stem from that as well.
Potentially even more, honestly, Mike, because the question still, I feel like it's so unanswered as far as what happens with inventorship when it comes to artificial intelligence.
Absolutely. And so when it comes to infringement liability, we would necessarily have to go back to the issue of who or whom or he or she or whatever. Who do we hold responsible? So who do you target? So coming from a litigation standpoint, who do you target? Do you target the end user of the products? Do you target the developer or seller of the product? In this case, being the artificial intelligence mechanism, or do you target the developer of the AI? And I think that we have to go back to what we've been doing before because the law hasn't caught up. So now we have to look at ideas or legal concepts like holding a product's manufacturer liable for patent infringement, which is certainly common practice in patent litigation. So do we use that as a template moving forward? Do we look at other areas of the law? One that springs to mind is in products liability litigation, where you hold a manufacturer liable for defects in products or defects in designs that inevitably hurt someone. So I think these are all questions that are going to need to be answered, and frankly, they're going to need to be answered quickly. But I can assure you of one thing, is that when it comes to infringement of someone's patent by AI or the resulting product of that AI, the court's going to hold someone liable. And I use that term someone very, very stringently, meaning the courts will not say that AI has standing to become a defendant. They're going to do what we talked about earlier. They're going to go further down the line to find an actual physical human being and hold that person or that legal entity responsible.
Yeah, for sure. Definitely, they'll be litigating against the assignee of the patent. I also think, though, that there's another point that needs to be made here with respect to patent prosecution. If you have all of these businesses that have relatively similar technological capabilities of using artificial intelligence to develop these products, I think that it's going to be a filing race to the USPTO as to who can get their invention filed quick enough to be able to then get a patent. Because if everybody has a similar technology that's able to invent a similar device, you're going to need to be able to get to the USPTO pretty quick, or else someone is going to beat you to it. And you're going to then be subject to litigation, as Mike was talking about.
Yeah. So I guess from moving from that point and into public policy, as far as just what comes from this, what kind of rulings, what does this ruling necessarily mean for artificial intelligence? Because I think we can all agree this isn't the last time we're going to hear about artificial intelligence or anything related to inventorship with artificial intelligence. So
I think one could definitely make the argument that whether or not artificial intelligence can be an inventor is moot, because the people setting the parameters and creating the experiments that the artificial intelligence run will then just be listed as inventors instead by the organizations and companies that have this technology. That being said, I think there is a question still as to whether or not these people can be considered an inventor, excuse me. The USPTO defines inventor as one who contributes to the conception of an invention. So I believe that the issue would become, do these people who set up these search parameters, is that contributing enough to the conception of the invention to be listed as an inventor?
And AJ, I think that's a really good question. And this goes back to what I was saying before, is trying to establish or trying to shoehorn your facts into, we won't call it an archaic framework, but a framework that has not evolved to the point where it lends itself to what we're discussing. So when we're discussing AI, you're talking about search parameters, you're talking about coding, you're talking about all of these extensive technological aspects. Is that conception? And frankly, that's where I'm saying we're going to have a lot of litigation. And frankly, I don't think very much guidance from either the USPTO or pre-existing case law or even Congress itself. I don't think it's going to alleviate any of these issues or clarify any of these issues anytime soon. I think maybe from a global perspective, it's interesting to show the bit of irony that all of these artificial intelligence systems have kind of created. The express point of all of these AI systems is that they were created to solve problems while minimizing human error or human involvement. But when we talk about either the litigation aspects or the evolving legal aspects of it, all they've done is taken the issues and the problems and transferred it to the legal side. And I think that the irony certainly isn't lost and is something that we're going to be litigating for quite a while. And for people like me, it's great because it means that I have a job. But at the same time, it needs to be pondered whether or not that is, in fact, going to hinder the advancement of technology.
Great point, Mike. And with that, we're going to wrap up today's podcast. Thank you for listening to episode 1 of Associate Chatter, and we hope you tune in for more episodes to come. Like we said, we are associates at SpencePC, and if you have any questions related to artificial intelligence or in general just intellectual property or litigation, please feel free to reach out to us. Once again, my name is Gopal Ganamraj, and I was joined today by Mike McDonough and AJ Wen. So if you have any questions, please reach out to SpencePC. We hope to hear from you soon. Have a nice day, and we'll be back for episode 2 soon. Thanks.